Module 1 refers to the relevant legislation required for the lawful possession and use of the firearm. In this training material, what we'll do is we'll go through what we feel is the most relevant sections of the Act that you need to know. But you need to refer to your manual. In the manual, they've got all the applicable sections of the Firearms Control Act, the Dangerous Weapons Amendments Act, and all the relevant sections of the Acts that you need to know to be deemed competent at the end of the day. Realize again that what we're trying to do here is just give you a basic overview in terms of the law. We are not lawyers and we don't profess to be one. So all we're trying to do here is give you a basic overview, but at the end of the day, realize that the law is very open to interpretation. And each individual case will be judged on its own individual merits. So we'll give you our interpretation of when you can, when you can't use the firearm, but realize that it's not how it is, it's just our interpretation. So maybe what you might need to do is consult a lawyer and see what your rights are and when you can and can't use the firearm. And again, we just reiterated that this is just a basic overview in terms of the law. What we'll do now is we'll just quickly run through the relevant sections of the Act. We'll start firstly with prohibited firearms. Any fully automatic firearm, cannon, recoilless gun, mortar, self-propelled, grenade, bomb, frame, body or barrel, or in imitation of any of these devices will be classified as a prohibited firearm. Where the mechanism or the caliber or the barrel length or the serial number or identifying mark has been altered without the written permission of the registrar will be classified as a prohibited firearm. Devices not considered firearms for the purposes of this Act refer to any explosive-powered industrial tools for mining, an antique firearm, an air gun where the caliber is .177, what they call a number 1, a number 2, which is a .22 caliber, would have to have a license. So any air gun that's .177 caliber, you don't need a license for. Tranquilizer firearm, paintball gun, flare gun, or deactivated firearm would be devices not considered as firearms. Competency certificates, license permits, and authorizations. The registrar may issue any competency certificate, license permit, or authorization once they've got the prescribed forms, your fingerprints, and the applicant complies with the requirements of the Act. And you must have a competency certificate before you can apply for your firearm license. Remember, you need to go for training at an accredited provider, and the provider will issue you with a proficiency certificate, but you then need to apply for a competency certificate before you can apply for your firearm license. Application for competency certificates. A certificate must specify whether it relates to possession of a firearm, to trade in firearms, to manufacture firearms, or conduct business with firearms. And your competency certificate lapses after a period of 5 years. So your competency certificate is only valid for 5 years. It needs to be renewed every 5 years. Additional licenses. The registrar may issue an additional license in respect of firearms where if your spouse, for instance, lives on the same premises as you, you can apply for an additional firearm license. So in effect, you can have 2 licenses for 1 firearm. Then license to possess firearm for self-defense. You can have 1 license for self-defense and licenses for business purposes. If you conduct business in security or firearm training or as a hunter, you need to apply for licenses for business purposes. Because your security officers, for instance, in the execution of their duties, they cannot use their own firearms. They need to use company firearms. So therefore, you need to apply for a competency certificate for business purposes. The holder of a license may allow another person to use the firearm. Despite anything to the contrary in this Act, but subject to Section 125, any person who is at least 21 years of age and the holder of a license to possess a firearm issued in terms of this Act may allow another person to use the firearm if one, while they're under their direct supervision, where it is safe to use the firearm, for instance on a shooting range or should you go hunting, it must be deemed safe to use the firearm and for a lawful purpose. Renewal of firearm licenses. If your license expires 90 days before date of expiry, you need to reapply for your competence certificate and for your license. So 90 days before date of expiry. Notification of change of address. If your physical or your postal address changes, you need to inform the registrar in writing within 30 days. And they say the registrar must in 30 days acknowledge receipt of that notice in writing. Period of validity for licenses or permits. As you can see here, a license for self-defense is 5 years. Restricted firearm for self-defense is 2 years. Occasional hunting and sport shooting would be 10 years. And then any collection, private collection of ammunition or firearms or in public collection is 10 years. Your license for business in hunting is 5 years, and any other business is 2 years. So your competency certificate may be valid for 5 years, and your license may be valid for 10, which means every 5 years you need to reapply for your competency certificate, although your license may be valid for 10. Defaced, lost, or stolen licenses, permits, and authorizations. If your license is lost, stolen, or defaced, you need to report that license being stolen within 24 hours. And then the Act also states that within 7 days, you need to reapply for the application of that license or the renewal of that license. So you need to report it within 24 hours, and then within 7 days, you need to reapply for that license. Prohibition of unlicensed trading in firearms or ammunition. Only a dealer may trade in firearms or ammunition, and the law is very specific on that. You may not trade in any firearm or ammunition without a dealer's license, and you may only dispose of a firearm or ammunition through a dealer. Well, obviously, if like the amnesty is on at the moment, you can then hand your firearm over to the police and dispose of it that way too. Carrying a firearm in a public place. No person may carry a firearm in a public place unless the firearm is carried, in the case of a handgun, in a holster, in a rucksack, or similar holder that's been designed or manufactured for the carrying of a firearm. Or in any other case of a firearm, it must be carried in a suitable case or holder designed and manufactured for the carrying of the firearm. Like a rifle, for instance, it needs to be in a rifle bag or a rifle case, which has been adapted for the carrying of that firearm. And the next section says the firearm must be completely covered. Now, this would not relate to security officers or police personnel or correctional services. Duties of a holder of permit. If a police official asks for the permit to inspect the permit, then obviously the holder of the permit must allow the policeman to inspect his firearm, his ammunition, and obviously if any of that ammunition is in his possession, then the policeman has the right to inspect that. Possession of or prohibition of possession of ammunition. No person may possess any ammunition unless he or she holds a license which is capable of discharging that ammunition or holds a permit. So like a security guard, for instance, he won't have a license for the firearm or the ammunition, but he'll have a permit. Restrictions on possession of ammunition. According to the new Act now, you're only entitled to 200 rounds or 200 cartridges per license. And the limitation does not apply to a dedicated hunter or a dedicated sports person. So if you're dedicated with the police as a sportsman or a hunter, then the 200 rounds does not apply to you. For those people who still have licenses under the old Arms and Ammunition Act up until, say, 2008, when they need to reapply, these restrictions do not apply to them now. But obviously, once they have licenses on the new Act, then this restriction will come into place. Loading or reloading of ammunition. Section 45(1) does not apply to the loading of ammunition by the holder of a license to possess a firearm in use of a licensed firearm. And a holder of a license contemplated in this section may not have more than 2,400 primers in their possession at any one time. Renewal of firearm licenses. With the renewals now, in the beginning they were looking at going according to alphabetical order, but they've decided to go according to birth dates. So January to March, people need to apply in 2005, which means your license will expire in 2005. And remember, previously we discussed that 90 days before date of expiry, you need to reapply. Then obviously, April, May, June is 2006, and so it carries on each for 3 months to add a year. Safes and safekeeping. This falls under Section 87 of the Firearms Control Act. Section 87 states that when a firearm is not under the direct personal and physical control of a holder of a license, the firearm and its ammunition must be stored in a safe or strong room that conforms to the prescripts of SABS 9531 and 9532. And 9531 is for your handgun safes or your firearm safes, and 9532 is your strong rooms or vaults. Now, your safes, here's a typical safe that is SABS approved. You'll see there is a sticker on it which conforms to SABS 953. There's a serial number on it. And basically on the 9531 safes, they're looking at a wall thickness and floor thickness no less than 2.8 millimeters, but can be thicker. And then the door thickness must be no less than 5.75 millimeters or thicker. So this is a typical handgun safe that conforms to the SABS prescripts of 9531. Now, again, it must be iterated that if the gun is not on your person or where you can exercise effective control, The firearm and its ammunition must be stored in the prescribed safe. The safe must also be fixed to a wall. If it's less than 300 kilograms in mass, the safe has to be bolted to the wall or to the floor. And that is SABS requirements. If you want to study up further on this, the SABS have the unit standard 9531 and 9532, which you can research and find out what the exact particulars are there. The SERA Act. Basically, the SERA Act says that any security service provider must provide a firearm for the security officer. The security officer cannot use his personal firearm in the execution of his duties. So this part of the Act here states that the security company must provide the firearm for those purposes, and obviously the security company must be registered for business purposes. You'll see Regulation 13.6. A security officer may, for the purpose of rendering a security service in the course of his or her employment, only possess a firearm lawfully provided by his or her employer. Criminal Procedures Act 51/1977, Section 20. The state may seize certain articles. Basically, this Act states that if the state believes that you have any article in your possession that has been used in the commission of an offense, they can seize it. So basically, that's what that Act says there. Search of arrested person and seizure of article. On the arrest of any person, the person making the arrest or under the control of the arrested person, if he is a peace officer, arrest the person, and any article that is found on the person, he can take control of that object, but obviously needs to hand that over to the police immediately. He may not keep it in his pocket for 5 days, he needs to hand that over immediately once he's seized it. Search of premises. Any person who is a lawful occupier or lawful owner may search a premises if a police official is not available. And if he finds any article on their premises that he has confiscated, again, he needs to hand that immediately over to the police. Search to be conducted in a decent and orderly manner. Only a woman may be searched by a woman. So if a woman police official is not available, the male police official may nominate another female to search that woman, but a woman cannot be searched by a man. Manner and effect of arrest. An arrest shall be effected with or without a warrant, and the person being arrested, number one, needs to be informed immediately of the cause of arrest or why he's been arrested. You can arrest this person by either touching his body or forcibly confining his body, whichever is applicable. The person effecting an arrest shall at the time or immediately after arresting the person or effecting the arrest, inform the arrested person as to why they're arresting him. This is very important. You need to inform the person why you're arresting him. The effect of an arrest shall be that the person arrested shall be in lawful custody. So as a private individual, should you arrest someone, you need to immediately hand them over to the police. Private persons to assist in arrest when called upon. Every male inhabitant of the Republic of South Africa between the age of 16 and 60 is obliged to help a police officer in execution of an arrest. If you fail to help the police official, you could be liable of a fine of 300 Rand or an imprisonment period of not exceeding 1 year. Breaking open premises for the purpose of arrest. Any person who lawfully arrests another person in respect of any offence and who knows or reasonably suspects such other person to be on any premises may, if he first audibly demands entry into such premises and notifies the purpose for which he seeks entry and fails to gain entry, may break open, enter and search premises for the purposes of effecting the arrest. Section 49, use of force in effecting an arrest. Arrestor means any person authorized under this Act to arrest or to assist in arresting a suspect, and suspect means any person in respect of whom an arrestor has or had a reasonable suspicion that such person is committing or has committed an offence. Now, as the arrestor, the only time you may use force is if that force is proportional to the set of circumstances in which you're trying to arrest this person. If you're using deadly force, it's important to understand that as the arrestor, you must believe, number one, that future death or future grievous bodily harm is imminent, that the suspect may cause serious bodily harm to the arrestor, or that a likelihood that the arrestor could die, only then could you use deadly force. So in a practical scenario, if a suspect stole something, for instance, and it related to property, like he stole your car, and he then drove off with your car, as the arrestor, if you're trying to arrest this person, you cannot shoot him, because there's no clear indication that future death or future grievous bodily harm is imminent. So the only time the arrestor can use this firearm or use deadly force is if you believe that the suspect is causing grievous bodily harm to yourself or to life, or to someone else's life or grievous bodily harm to someone else, only then could you use your firearm or apply deadly force. So Section 49 deals entirely with that. And if you look in the manuals, you'll see there's a clear section in terms of Section 49 of when you can and when you can't use your firearm. And this is very important to understand here, because this is, in essence, what this entire legal section is about, as to when you can and when you can't use your firearm. And the best advice I can give you is that if you feel that your life or someone else's life is in imminent danger, or that grievous bodily harm could be caused, only then use deadly force. Other than that, if it's for property, try and arrest the person. But if the person is resisting arrest and he flees, and there's no clear indication that there's a threat to life or grievous bodily harm, then don't apply deadly force. So Section 49 deals entirely with that. Serious offences: if anyone commits or attempts to commit a serious offence in your presence, then you may arrest that person. But again, in arresting that person, you may only use the force that is reasonably necessary in the situation to subdue the suspect. Section 50, procedure after arrest. Any person who is arrested with or without a warrant shall as soon as possible be brought to a police station. And that's important. Once you've arrested the person, you need to immediately hand them over to the police. Supremacy of Constitution is basically the Bill of Rights. And the Bill of Rights says everyone has the right to life. So understand that if you're trying to arrest this person, realize that the highest power in this country cannot sentence someone to death because of this supremacy of right. So everyone has the right to life, and we need to respect that. Everyone has the right to privacy, which includes the right not to have their personal home searched, their property searched, their possessions seized, or the privacy of their communications infringed. Arrested and detained persons need to understand that if you are arrested, you have the right to remain silent and to be informed of that right to remain silent. And if a statement needs to be given, that you would like an attorney or some kind of legal representative to be present when you afford in your statement. Vicarious liability. Vicarious liability is where one person controls the actions of another. For instance, if as an employer I give one of my employees a motor vehicle to do a delivery, if I know that that motor vehicle is not roadworthy and that person is involved in an accident, I could be held vicariously liable for the damages. There's other forms of vicarious liability. For instance, if you walk in with your child, you should be in control of the child. Should the child run across the road and a car hits the child, you could be vicariously liable for the damages because you should have controlled the child in some way. So that covers vicarious liability. Civil liability and criminal liability. Criminal liability is basically where someone commits a crime against society, the state will charge you in a criminal court. Civil liability is basically monetary terms. So where one sues another for monetary purposes, that will be civil. And realize that if you arrest someone or use deadly force, you could not only be criminally liable, but you could be civilly liable as well in terms of damages that are incurred. The Dangerous Weapons Amendment Act of 1993. This act states that any person who is in possession of any dangerous weapon or any object which so resembles a firearm that under any circumstances such as those under which such person is in possession thereof is likely to be mistaken for a real firearm shall be guilty of an offense. And basically this says if someone holds you up with a toy firearm and you didn't know that it was a toy gun and you used deadly force to stop the person, he was in violation of the Dangerous Weapons Amendment Act. This section of the law now, we're going to deal with Section 49, which is the use of force. In order to understand this process in terms of the law, when you can and when you can't shoot, it's a very debatable issue. You need to understand that the law is open to interpretation. What I'm doing here is giving you my interpretation. I'm not a lawyer and I don't profess to be one, so what I'll be giving you is just basic guidelines as to what we've seen and experienced over the years in terms of people using their firearms in self-defense. Now, the question is often asked, when can I use my firearm? In what situation can I use my firearm? Hopefully we can clarify that by just going through this process now. But let me run you through a couple of scenarios firstly. Let's say you go to the bank, you draw 50,000 Rand. You now come out of the bank, next thing, criminal runs up, puts a gun to your head, grabs the 50,000 and runs. What would you do? The most common answer that we get from that is, well, I'll fire a warning shot, or I'll try to run after the person, or others say they would shoot. Let's give you another scenario. You're sitting at home watching TV. Someone starts forcing the front door with a crowbar. You produce your firearm, you tell the person to stop, but he doesn't stop. He just continues forcing the door. He's now entered your home with the crowbar. What would you do? Again, the most common response is, I'd shoot. The other example that we often give to is a criminal has now gained access into your house. He's got a firearm. He starts firing at you. You have access to your firearm. What would you do? Again, the most common response is shoot. If, say, now you've used your firearm in self-defense, we need to understand that the police now are what we would call procedure-based. Should you use your firearm, they're not going to charge you with self-defense or private defense. They are going to charge you with murder. If you've killed that person, they will charge you with murder. If you've wounded that person, they'll charge you with attempted murder. So that's the charge you're defending straight off the bat. If we now proceed to court, you're now in court, you're going to have to answer to certain questions and certain criteria in terms of why or how you used your firearm in self-defense. Let's look at this criteria. The criteria relates to two things. Number one, there must have been an attack, and number two, there must have been a defense. The criteria relating to the attack. The attack number one must be unlawful. I guess what they mean by that is that, well, let me ask you another question. Can someone attack you lawfully? The lawful process would be if you as a security guard or as a private individual try and arrest someone. If you use the necessary force to arrest that person, that would be deemed as lawful. It's the same as if a policeman tries to arrest you and he uses the necessary force to arrest you, that would be deemed as lawful. So the attack number one must be unlawful. Number two, the attack must be against life. Now this used to read the attack must be against a legal interest, either life or property, but the property clause has fallen away. The attack now must be against life. It doesn't necessarily have to be your life, as long as someone's life is in imminent danger when you use the firearm. And then thirdly, the attack must have commenced or was imminent. Commenced means he's already attacking you or he's already shooting at you. Obviously, imminent means he's just about to. So if this criteria is in place, if the attack is unlawful, against life, commenced or imminent, you would have the right to defend yourself. Now, the Firearms Control Act says that if you have a license issued under the self-defense aspects, you can use a firearm where it is safe to use the gun or for a lawful purpose, and this would be deemed as a lawful purpose. Your defense now, number one, must be reasonable. Now, reasonable means, the best way I can explain this to you, they will ask, would a reasonable person in the same situation you were in, would he have acted the same way? Now this is very subjective. To me, reasonable also means, what else could you have done to avert the attack? Did you try something else other than using deadly force? Did you try talking to the person? Did you try run away? Or did you just produce the firearm and fire? So the reasonable aspect in terms of your defense is something you're going to have to justify. Secondly, did you meet force with force? I guess what is meant here is if someone attacks you with their hands, you should defend yourself with your hands. Now I know this is a contentious issue with women because women say they don't have the physical strength against a man. But let's say if someone was overpowering you physically with their hands, could you not then escalate it to maybe a baton or a pepper spray or other than just drawing the firearm and firing? So you need to try and escalate the level of force which is relevant to the attack. What they're not saying here is that you can't, if someone attacks with the hands, you can't just produce your gun and shoot. Okay, you need to first escalate meet force with force, and if that's overpowering, then escalate it slowly. It's the same as if someone attacks you with a brick. Does that mean you need to find the same size, shape, color of brick to defend yourself? No. The way I see that is if someone produces a brick, that to me would be excessive force, not force. Chances are he could kill me with that brick, or he could do serious bodily harm with the brick. So therefore, if he was using a brick, I would meet that with excessive force. It's the same as if someone produces a knife. Would that be deemed as force or excessive? The way I see it, that would be deemed as excessive force. Because again, he could kill you or cause grievous bodily harm with a knife. So, meeting force with force, this third one is, you need to direct your defense against the attacker and not a third party. What is meant here is that if there's 3 people attacking you, you may only defend against the person who's posing a threat to your life. If the other two are just bystanders watching, or not bystanders, but they're part of this process, but they're just watching, but they don't pose a physical threat to you, you cannot defend yourself against those people. You can only direct your defense against someone who's actually attacking you. Even though those other two may be inciting the violence, but the fact that they're not armed and they're not posing a threat to you, you cannot obviously defend yourself against those people. What I'm saying is for deadly force. So, the attack number 1 must be unlawful, against life, commenced or imminent. Your defense must be reasonable, you must meet force with force, and you must direct your defense against the attacker, not a third party. Let's put this in this practical scenario now. They stole you 50,000 rand, they ran away, and let's say you shot them. The police today are what we would call procedure-based. They are going to charge you with murder. So you charged with murder, you are claiming private defense. You're now in court. The first question they're going to ask is, was the attack unlawful? Well, him stealing your 50,000 rand and pointing a gun at you, I would say is unlawful. So yes, it was unlawful. Was it against life? Well, at the time you defended yourself, what was he actually doing? He was running away. So how can you say that your life was in danger? So this is no. Was the attack commenced or imminent? At the time you defended yourself, because he was running away, he wasn't posing a threat to you. So it wasn't commenced or imminent, it was actually over. So this is no. Your defense, was it reasonable? Well, to you it might be very reasonable. It's your 50,000 rand running down the road. But to a court, I don't know. So we'll just put a question mark there. Did you meet force with force? At the time you defended yourself, he was running. Was he pointing a firearm at you? Was he firing the gun at you? No. So that's no. Thirdly, did you direct your defense against the attacker, not a third party? Yes, that we did do. If we look at this practically now, you've got a yes, a no, a question mark, a no, and a yes. To me, this is leaning more towards murder. This is not private defense. We need to also understand that the highest power in this country cannot sentence someone to death. Because of the Constitution, everyone now has the right to life. So just because you own a firearm doesn't mean that you can just kill people. Okay, so let's look at the second scenario. The person's forcing your front door with a crowbar. He now enters the house, threatens you with a crowbar, and let's say we shot this person. Was the attack unlawful? Yes, it was. Was it against life with a crowbar? Yes, it was. Was it commenced or imminent? Well, it's imminent. He's just about to attack you. To shoot that person would be reasonable? Well, to you, yeah, very reasonable. Did you meet force with force? Well, the fact that he's got a crowbar, could he kill you or do serious bodily harm with it? In my book, yes. So you would be meeting excessive force with excessive force. And did you direct your defense against the attacker, not a third party? Yes, that we did do. Here we now have a yes, a yes, a yes, a question mark, a yes, and a yes. This is leaning more towards self-defense or private defense, but it's not there yet. Let's say now the person's in your house, the criminal. He's now firing at you. What did we do? We shot him. Was it unlawful? Yes. Against life? Yes. Commenced or imminent? Yes. Reasonable to shoot? To you, very reasonable. To meet force with force? He used a firearm, I used a firearm? Yes. Did you direct against the attacker, not a third party? Yes. Again, this is leaning towards private defense, but it's not there yet. Why this? Well, what we need to understand here is that each individual case will be judged on its own individual merits. You are going to need to justify why you used that firearm. The first thing they're going to look at, if they've charged you with murder, they want to know if you used this firearm with intent. Now, most often when we use a gun, we always say we shot him, or he attacked me, so I blew his head off. If you're saying it like that, obviously that is intent. And for them to find you guilty of murder, they need to find intent. Remember, just charging you with murder is one thing. Finding you guilty is something completely different. But they're looking at your attitude or your frame of mind when you use the firearm. Now, for me personally, the only time I would ever use a gun would be to stop someone attacking myself, my family, or my property. It's not to shoot, not to kill, not to wound, not to threaten, but to stop. That's the only reason why I carry a firearm. What I mean by this is, let's say 6 criminals are breaking into my car. I run outside with no firearm. I jump out and I say, guys, get out of my car, otherwise I'm going to sort you out. What are my chances of stopping them on a scale of 0 to 10? In my book, I would say it's about naught. But let's say I have a firearm now. I run outside with a pump-action shotgun. I point the shotgun and say, guys, I'm now placing you under arrest. What are my chances of stopping them? To me, on a scale of 0 to 10, even if it goes to 1, that to me is a hell of a lot better than 0. And that's the only reason why I carry a firearm. Should the mere fact that I point the firearm, they stop attacking my car and run away, that's all I wanted. If, on the other hand, they stop attacking the car, they now direct their attack onto me. If they start producing firearms and start presenting a threat to myself, I'm going to use the gun to stop them. Not to shoot them, not to wound them, not to threaten them, but to stop. And if I fire one shot and the attack stops, well, so be it. Then I stop my defense. Realize too, that by going outside with the firearm, I could be putting myself in a position where I may have to use that gun. So that's something you're going to have to mull up in your head very quickly. Is it worth going outside, getting killed for your car? Or is it worth going outside, having to shoot someone or kill someone or stop someone attacking your car? So the only purpose why you should be carrying a firearm is to stop someone attacking yourself, your family, or your property. We truly believe there's 3 things we need to survive. Number 1, the situation. Number 2, the legal system. And number 3, your moral conscience. Realize that when someone attacks you, you need to survive that first. Because if you don't survive the situation, you don't need to bother about the rest because we're not around anymore. The legal system, there's going to be legal recourse. If, as a security officer, if you try and arrest someone and you use the necessary force to arrest that person, and let's say you gave him a good smack, they are going to charge you with assault. So whether you used your firearm, whether you used your hands, there's going to be a legal process. Okay. And thirdly, your moral conscience. Whatever action you've decided to enact, you need to live with that for the rest of your life. And that's something you need to be well aware of. So if we survive the situation, we survive the legal system, and you survive your moral conscience, I truly believe you've survived. So based on this, we have a very simple rule. If in doubt, don't. If you're standing there thinking, should I, shouldn't I suggest you don't. But if there is no doubt, we then stop the attack. And remember, stopping the attack doesn't necessarily mean producing your firearm and firing. Stopping the attack can also mean running away. Stopping the attack can mean talking to the person. What else can you try and do to stop the attack other than using your firearm? But obviously, if you're in a situation where your life or someone else's life is in immediate danger, then we need to resort to a firearm to stop the attack immediately. So our simple rule again, if in doubt, don't. And if there's no doubt, stop the attack.